Travis and Mr. Rubin. This thing got louder. All right, back on. All right, got all the defendants, most of counsel. Mr. Rubin. Any idea where Mr. Rubin may be? Okay. Before we get started, Mr. Goff.
No, I was just giving the court a heads up. I had brought up the Veterans Day issue before. Under OCGA 1-4-1, we contend that Veterans Day is dies non juridicus. It's a non-judicial day when court can't be conducted. Now, there is an 1888 Georgia Supreme Court case that would beg to differ, Hughes v. Sears or Hamer v. Sears. However, under federal law, it is apparently an open question, although you can't raise it in habeas. Hudson v. Edge, 218 U.S. District Lexus 105463. Since the Hamer case was decided in 1888, which seems to be what a few cases since then go back to, the federal law, I think, has changed with respect to the Establishment Clause of the Constitution. It would seem that either all of the holidays are not judicial days or none of them are. You can't single out Sunday as opposed to the others. So I'm going to suggest that the court reconsider that issue, and in the alternative, and I'll try and get more information for tomorrow, maybe starting later or having a half day, allowing jurors to attend Veterans Day services in the morning. There's usually one downtown. Just throwing that out there to the court. I would also add, from a purely selfish perspective, if we're going to be in court for a month straight, I think all the parties, maybe even potentially the court, might want a half day or a day off during that period of time to take care of things. I know I was able to get to the dry cleaners this morning, but I have no shirts to wear on Friday unless I can get back there tomorrow. I'm just suggesting that the court consider, in addition to the legal argument, the practical argument that a day between now and Thanksgiving or a half day is going to be essential to everyone. I'm sure there are people in Savannah that might even like to see you during business day, but just bringing that up.
Take that all under consideration. All right. Mr. Sheffield, ready to go? All right. Got all the defendants represented by counsel. Let's go ahead and get the panel.
Cedric, we need you to come back.
I mean, I'm tangled up in cords. Mark's close enough to her to help.
All rise for the jury, please.
We've got our count right. We've made sure of that.
All right, good.
All right. Welcome back, ladies and gentlemen. We are ready to proceed with the evidence. Mr. Sheffield.
Investigator, when you were talking with Greg, did you at all get him to draw a map of Secure Shores for you to kind of explain what he was doing?
We used Google Maps, and then I did a rough sketch myself. He didn't do it.
Okay. Did you draw a map?
I drew the roads as we're looking at them here, and then had little tick marks showing which way they went.
Oh,
Yes,
do
sir.
you have that with you?
No, sir.
Did he mark on it, or did he just talk to you and you kind of drew lines and asked if this was correct?
He talked to me, and I drew the lines.
Okay, all right, very good. You did not take him out to the neighborhood to walk it with him or ask him to demonstrate anything to you out in the neighborhood, though, did you?
No, sir.
Okay. I think when you said you saw Travis back in the headquarters?
Yes, sir.
Okay. Did not do any interview of him, just saw that he had come down to be interviewed by Investor No-Hill. Is that correct?
Correct.
Okay. And I think you said when you saw him, he was still covered in his book.
Yes, sir.
Okay. He was just waiting to be interviewed or to be talked to?
He had gotten brought in by Officer Lewis, And when we saw how he presented with his clothing and blood, he asked to be able to clean up. I called Sergeant Oliver and Investigator Lowry, who were down at the scene, and asked them about that. They gave the go-ahead. We went in and photographed to show the state he was in when he brought up here,
Right.
and then allowed him to change.
Okay. He was, otherwise he was just very quiet.
Yes, sir.
Okay. One of the photographs that you showed us, I want to put it even a closer one. This right here is an injury to the back of his head. That's after let me just rephrase. That's after he's been wiped down with alcohol. Is that correct?
This is after he's been able to clean up,
Right.
but before I brought the alcohol pad to him at the beginning of Greg McMichael's interview.
Okay.
And I don't know what that actually is. I didn't
Okay.
document what the mark is.
All right. All we can say for sure is this is what's left after he's cleaned himself up.
Yes, sir.
Okay. And that's there on the back of his head, and then here's what's left after he's cleaned himself on his front left arm.
Yes, sir.
Okay. Very good. Now, do you have any experience with Satilla Shores, the neighborhood itself?
From time on patrol, I've answered a few calls in there and then just rode through on occasion.
Okay. Have you come to learn the makeup of the neighborhood in terms of, like old retirees live there? Are you aware of those kind of details?
I'd be assuming.
Oh, okay. We don't want you to do that. So you've not taken it upon yourself to kind of figure out the age of the people or the families or single people versus married people, that kind of thing?
No, sir. I have the experience with the. I've been in there for 8 calls that Spillman logs, and so I know the demographics on those 8 individual houses I've been to, and then this case. But past that, I don't know the demographic breakdown, finances, anything like
Got
that.
it. So you yourself have gone to 8 specific calls in that neighborhood
Yes, sir.
over 18, 19, and 20?
Since 2015, when we switched over to Spillman's system, and I can search Spillman.
Okay.
Spillman that way.
So we talked a little bit about this system, but
Yes.
essentially there is a system for Glynn County that keeps track of the calls that come in particular areas, all the way down to the address of
Yes,
the
sir.
call. Okay. And the call type is something that's determined by the operator that takes the call. Is that correct?
Generally, and then it can be changed later. So if something's unfounded and it was listed armed robbery, but it turned out to be a problem with person, the officer can change it later
Okay.
if appropriate.
All right. And it's essentially just based on what the citizen says that's calling.
Yes, sir.
Okay. Now, one of the things that we started to talk about was you went into 220 Satilla to take a look around at night.
Yes, sir.
Okay. And because, is it fair to say you did that because Greg McMichael was telling you what he believed Mr. Arbery was doing in that residence?
Yes, sir. And overall for the case, but
Right.
generally,
So
yes, sir.
it's by going there, you are looking to determine or to try to understand that somebody may have entered that dwelling with the intent to take something.
We're going in to get a picture, get an idea of what the structure is, what's inside of it. So all facets, not just theft, but also, what state is it in? Is there anything obviously stolen? Is there anything obviously not stolen? Completely void. We went in for all those reasons.
Okay, but one of those reasons is to determine if this is a dwelling or a structure that somebody could go in there to steal stuff.
Yes, sir.
Okay, and the idea is you've been told about break-ins.
Yes, sir.
That doesn't require something to get broken. You don't have to kick a door or break a window to make a break-in.
No, it's commonly used for just going in, entering. Yeah.
Burglary, don't have to actually steal something. It's just entering with the intent to steal something.
Objection at this time. This is the law that the court is going to give the jury to ask this officer, or actually to have Mr. Sheffield testify to what the law is and ask this officer to agree with it is inappropriate.
Objection inappropriate, I don't think is a legal objection. The reason I'm asking these questions, though, is because he's investigating, and I want to understand the way he's investigating and the decisions that he's making. So I'm asking him to help me understand that he's going in there to determine whether or not a burglary or some type of intent to enter to steal. That's all.
Okay, well, the relevance of defining, that's really the objection.
Well,
So,
yes.
well, you don't need to argue with me either.
Sorry, I'm not-
So it's actually sustained relevance. As the court has already instructed the panel a number of times, the law will be given to you from the court. And again, what lawyers say is not testimony or evidence in the case. Couched in those terms, you can ask him what he thinks, but let's not go ahead and define it for him.
Okay. So when you're trying to, what are you trying to figure out when you've been told that somebody committed a burglary?
Objection. Facts not in evidence. Nobody's told him that anybody committed a burglary. And so therefore, especially that day, to ask him about this is facts not in evidence, and counsel's trying to testify.
You were told that somebody committed a burglary, weren't you?
Just told he was going in there repeatedly, and break-ins was used, burglaries was used for the neighborhood throughout.
On solid
That's
ground.
a sustained because that's Mr. McMichael's statement, and he's already testified that he did not follow up on that. So it's sustained.
Okay. You did not follow up to try to determine if a burglary had been committed at 220?
Objection. Once again, formal question, on what day?
He's already testified to what he did, and you've asked him, it was either you or
Oh, why I'm so confused here, Judge. Go ahead. I'm sorry, I'm following.
Ladies and gentlemen, if you could please take a step outside.
Please stand.
Mr. Sheffield?
Yes, sir.
You can agree or disagree with this court. That is your prerogative. But to act in the way that you just did in front of this panel, disrespect, I don't care whether you like my rulings or not, or you like me or not, but in this court, the Superior Court, it is axiomatic that counsel show at least respect for what the court is doing. And what you just did shows a lack of respect for what the court is trying to do here, which is create an environment which is fair to all parties. I would suggest that you take a moment to think about that. I'm going to step off the bench because I found that, I'll just call it rude. All right? I have tolerated a number of things in the courtroom, including, flip charts, writing in the middle of, the jury gets distracted when you were doing the flip charts here, jumping up and moving the boards. I would suggest that you temper some of that very quickly because it will not be tolerated in this court, and I will leave it at that. I do not need an explanation. I do not need an apology, none of that. But I would suggest that we take a moment and think about the way that you're reacting to the court's instructions and rulings. We're in recess. Thank you.